Great to be learning with you on a Sunday. Let's light up the darkness. We're doing a double daf today. We're going to skip a few sections, but do a lot of it, so we're going to be efficient. Bill in Mid-Missouri, welcome. Paul in the Great Northwest. Lucy in Minnesota. Melissa in Great Neck. Bella in Florida. Shandor in the Bronx. Ryan in Jacksonville. Sharon in New Jersey. Joe in the Inland Empire. Debbie in New Jersey. Welcome, everybody. We're continuing to our discussion of Mishna number 1 here in chapter 1 of Bava Kamma, the 21st volume of the Talmud. We're talking about the types of damages and even what we mean by damages. It seems that we're separating types of incidents that can happen and result in, somebody was injured and needs to be made whole. And there's going to be a procedure, right, for making whole, a degree of liability, shall we say. And, how much is the owner of the animal or the pit or the fire or the person himself or herself that causes the damage? Who is the person responsible? How much are they going to be liable for? Just the physical damage, all of it, some of it? Are there going to be the additional types of indemnity, pain, humiliation, medical, loss of livelihood, or will those types of indemnity not accrue? And for this reason, the sages are spending a lot of time sort of systematizing the types of damage and damages that would be paid, trying to systematize the ones that are laid out in the Torah, in a way that we can extend the principles, understand the rules, and then, take those rules with us when we encounter other kinds of situations not mentioned in the Torah. So we continue this discussion right at the top of page 5a. And what we're doing here, so at the end, we were talking about that Rabbi Oshaya, right, so there was the ton of our Mishnah says there's 4 primary types of damages: ox, fire, pit, and maveh. And we've been talking about what does maveh mean. Shmuel says it's one of the categories of damage that an ox can do by eating somebody else's produce. But Rav said that maveh means man. In other words, what a person does directly, not through an animal or a pit or a fire that he started, but himself, hitting, spitting, throwing, etc. And then once we were, examining what are these categories of damage, we had other lists from Rabbi Oshaya and Rabbi Chia that were longer. And it didn't extend by going to other kinds of, animals or property that would cause damage, but rather different situations in which damages or fines, penalties, need to be paid. And Rabbi Oshaya said there were 13 types of categories where damages, or 13 types of damages, shall we say, and Rabbi Oshaya said 24. So we continue. Oshaya said 13 and Chia said 24. Okay, so we picked this up at the top of 5a, where we were examining Rabbi Chia's list of 24. And toward the end of that list, the Gemara asks, with regard to the payment made by conspiring witnesses, right? So if 2 witnesses conspire to present the testimony of 2 witnesses to assert that something is true in court that will result either in a criminal case, right, in the sort of conviction of the defendant who will be punished as a criminal, or the 2 conspiring witnesses conspired to present a falsehood as the truth in a civil liability case, which would result in the defendant having to pay damages. Well, if it turns out that the witnesses were liars and we're able to prove that, well, then the witnesses are going to become liable for exactly that which the defendant was going to have to pay, and then some, I hope. All right, let's go. So with regard to the payment made by conspiring witnesses, which is categorized as monetary restitution, as the witnesses pay the precise sum that they conspired to cause the defendant to lose, Plus, they're now known as liars, and I think they also are going to be liable to bring sin offerings for that, but that's a different issue. So let Rabbi Oshaya also teach it as one of the categories on his list. If he's talking about every instance where people have to pay damages to other people, why not include the conspiring witnesses? Rabbi Chia mentions it. Why doesn't Rabbi Oshaya? And the Gemara answers, Rabbi Oshaya holds in accordance with the opinion of Rabbi Akiva, who says that conspiring witnesses do not pay on the basis of their own admission. Evidently, theirs is not a payment of monetary restitution. Rather, it is a fine, as only one who was found liable based on the testimony of witnesses pays a fine, not one who was found liable based on his own admission. So when these conspiring witnesses end up having to pay a fine, it's because we bring more witnesses who show that the conspiring witnesses could not have seen what they claim to have seen in their testimony because they were somewhere else. So they must be liars, and that's where they become liable to pay what the defendant would have had to pay in damages were he found liable. So the Gemara asks, if Rabbi Oshaya holds in accordance with the opinion of Rabbi Akiva, let him teach two distinct types of categories of damage under the rubric of the ox. Let him teach one category of an ox that damages an ox or other property belonging to another person, and let him also teach the case of an ox that injures a person. And now we're going to get into the kind of logical sequence that we covered already a couple of times yesterday. So we're going to skip forward a little bit because we're doing 2 pages today to help us get caught up. So further down on page 5a, so he taught, Rabbi Chia taught that number right. In other words, we pick it up over here. The Gemara considers the fact that each of the lists of primary categories, right, our Mishna and Rabbi Oshai and Rabbi Chia, is introduced with a number, right? There are 4 categories, or there are 13 categories, or there are 24 categories. Now, granted, according to the Tana of our Mishnah, which said there are 4 categories, he taught the number 4 primary categories when he introduced his list. Why? In order to exclude those additional categories of Rabbi Oshaya. In other words, when you say there are 4, what you're saying is, and there's not 5 or 6 or 7 or 13 like Rabbi Oshaya says, there's only 4, right? So you taught that list of that number 4 to exclude those additional categories that Rabbi Oshaya includes in his list. And similarly, Rabbi Oshaya taught the number 13 primary categories to exclude those additional categories of Rabbi Chia. But what does the number 24 in Rabbi Chia's list, right? He says there's 24 categories. Now, is he saying and that's all of them? Or is he saying there's 24, but not some other ones? In other words, there are some others that you might have thought would be on the list, and there's not. There's only 24. That's what the Gemara is asking. So what does the number 24 in Rabbi Chia's list serve to exclude? And the Gemara answers, he taught that number in order to exclude the cases of an informer who provides information to the authorities, leading them to confiscate another person's property, right? This is like the traitor to his people who informs on them. Like if you especially in the history of the Jewish people in the diaspora, often living under regimes that were extremely hateful to the Jews, extremely dangerous to the Jews. Imagine living under the Tsar in the Pale of Settlement, 16, 17, 1800s. You have a grudge against your fellow Jew, and rather than take it, whatever is actually the problem between you and your neighbor, work it out between you or take it to some kind of rabbinic court and settle it within the Jewish world. Instead, the guy gets all highfalutin and angry, and he goes and informs on his neighbor for something he happens to know about because it's his neighbor. To the Russian authorities. That could result in the neighbor being imprisoned for years, his family losing the farm, losing everything. This is a very serious type of matter. And the informer within the Jewish world in that kind of a context is as hated and liable for damage as informers are in, any environment. Right, we're not talking about noble informers, whistleblowers. We're talking about something quite different than that. So let's see. So, but even though an informer would become liable to pay restitution for the loss that he caused his neighbor, let's say. That's not included in the kind of damages that Rabbi Chiya is talking about. And there's another case that Rabbi Chiya is also excluding, and that is the case of a priest, a Kohen, who renders an offering pigul by performing the sacrificial rites for one offering with the intent to sacrifice it for the sake of another offering. In other words, at the time he was bringing an offering, he spaced, or he was not being careful, or he did it on purpose. And he actually, some individual spent a lot of money, went on a pilgrimage journey to Jerusalem to bring an offering when the Holy Temple was standing, handed the animal over to the Kohen there at the temple, and the Kohen blew it, either unintentionally or intentionally, but he rendered the sacrifice invalid. And so the person who went through all this trouble, to make an atonement or to bring a peace offering or, make some kind of a korban, right, to bring this offering to achieve either atonement or peace or thanksgiving, praise at the temple, and it's obviated because the priest made a mistake. Does the priest have some liability in that? If he's utterly negligent, if he's intentionally hateful, he's going to have some kind of liability. But that's not the kind of case that Rabbi Chiya is including, right? A priest who does that with the intent to sacrifice for the sake of another offering, in which case the person who brought the offering must replace it with another, right? What is the priest's liability in that? It's a discussion for another day, but it's not included in Rabbi Chiya's list. So the Gemara asks, and let Rabbi Chiya teach these cases. Why doesn't he include the informer and the priest who brought the wrong offering or rendered it invalid? Granted that Rabbi Chiya does not include the case of a priest who renders an offering pigul, perhaps with regard to cases involving consecrated items, Rabbi Chiya does not speak, because that's a whole other body of law. But with regard to the case of an informer, what is the reason that Rabbi Chiya did not teach it and include it in his list of categories? And the Gemara answers, the case of an informer is different, as the damage is caused through speech. And with regard to damage caused through speech, Rabbi Chiya does not speak. Right? Of course, there's such a thing as slander and ruining someone's reputation and harming somebody else through speech. But here in this chapter, we're talking about actual physical damage. So the Gemara asks, but isn't there the case of a defamer where damage is caused through speech? And yet, Rabbi Chiya does teach it, does include that in his list. And the Gemara answers, well, he includes that case because it is a case of speech that involves an action. One who defames his wife, that's what we were talking about, is liable only if he made his allegation after engaging in intercourse with her, right? The defamer was the one who said after his wedding night, I thought I was marrying a virgin, and it turns out she wasn't. I mean, what? Yeah. Let's not even get into what kind of a, drama and unfortunate set of circumstances would lead to such a situation. But at any rate, that defamer, and especially if he lies, he's going to be liable for a lot. He has a lot to answer for. But that kind of speech is coupled with an action, whereas the informer is not. Pretty subtle distinction. Where are we? So the Gemara asks, but isn't the case of conspiring witnesses a case of speech that involves no action? They're just talking, as they're liable for their testimony. Rabbi Chiya teaches it and includes that on his list, and the Gemara answers, well, although it involves no action, the merciful one characterizes it as an action in the Torah, as it is written, Deuteronomy 19:19, and you shall do to him as he conspired to do unto his brother. Right, bringing false testimony to pervert justice. It's with words, but it's a serious action, and the Torah speaks of it that way. And the Gemara considers the subcategories of the various primary categories listed. Granted, according to the Tan of our Mishna, where there's 4, his terminology is understandable, as he taught primary categories, which by inference means that there are also additional forms of damage that are subcategories of those primary categories. But according to Rabbi Chiya, and his list of 13 types of damages, and Rabbi Oshaya and his list of 24, why did they employ the terminology that they employed? They employed the term primary categories, which by inference means that there are subcategories. Well, what are the subcategories of the primary categories as they organize their list when they included either 13 or 24 respectively? It appears that they enumerated all of the various categories of damage, and we're not going to talk about subcategories. So Rabbi Abahu says, when Rabbi Chia and Rabbi Oshaya characterize as primary categories the various categories of damage that they listed, it is not to indicate that there are subcategories. Rather, it is to indicate that all of them are characterized as primary categories, in the sense that one is liable to pay from one's best quality property. Right? It seems that what we're actually talking about here is, what do these things all have in common? We can come up with philosophical understandings. They all, either your property or something under your control, a situation you created, something that it is your responsibility to safeguard your property or your hand from doing damage to others. But really, what all these types of damages have in common is that once you become liable to pay, if you don't have cash on hand and you don't have movable property that you could liquidate, then you have to liquidate your real property, assuming you have it. And if you've got different levels of real property, low, medium, and high quality, you actually have to liquidate your high quality property in order to satisfy your liability to make whole the person that you injured. That's what all these primary categories have in common. So the Gemara asks, what is the reason for this? I.e., from where are you deriving that this is what's behind these lists? And the Gemara explains it is derived using a verbal analogy from the terms in place of, giving, he shall pay, and money. What does it mean? So the term in place of, this is written with regard to a forewarned ox that gores, Exodus 21:36. He shall give is written with regard to an ox that kills a slave. He shall pay is written with regard to the categories of damage for eating and trampling. That's Exodus 22:4. And money is written with regard to the pit, right? If you dig a pit and somebody else falls in it and trips, that's Exodus 21:34. So the halakha, the law that one must pay from his best quality property, is stated explicitly in each of these four verses. In each of the 24 categories listed by Rabbi Chia, one of those four terms is written. So, by means of verbal analogy, the requirement to pay from one's best quality property applies to each of them. That's how we know. Skip down a little bit on 5b. Rava said, and with regard to all of the primary categories in our Mishnah, when you cast the primary category of pit among them, right? So ox, fire, pit, and mave, which seems to be the direct actions of people, at least according to Rav. So Rava says, when you include pit in that list, so then all the rest of them can be derived through an analogy based on the common factor of two categories. And this is the case with all of the categories except for goring, due to the fact that there is room to refute the analogy to teach the law of goring with the following argument. What is notable about all of the other categories? They are notable in that they are forewarned from their outset, since it is the typical manner of an animal to trample wherever he goes. He doesn't care what he walks over. And it is the typical behavior of an animal to eat what is in front of him that is edible and tasty in the animal's opinion. And it is the typical manner of fire to burn and spread if wind blows it. And it is the typical manner of a pit to serve as an obstacle if you dig a pit and leave it in the public domain where people are going to walk into it or animals are going to walk into it. So in all these cases, the owner doesn't have to have been forewarned that the hazard, that his animal is a hazard. He knows that his animal will eat or trample. He knows that his fire will burn and could spread. He knows that his pit in the public domain could cause harm. We don't have to prove some additional aspect of that he was forewarned by somebody told him, hey, that could happen, or that other people fell into it in the past. You know that your animal, your pit, and your fire would do these things. So they're forewarned from the outset. But with regard to goring, That's different, right? We've said that there are oxen who gore and there are oxen who don't. Most oxen don't. So the average oxen, the typical ox, right? We do not assume that it is going to go and gore people with its horns. If it does it once, it might have been a freak occurrence. If it does it twice, it's pretty bad. If it does it 3 times, that's a habitual gorer. And if it does it one more time, the liability of the owner is very different than if it was an innocuous ox. So goring is unlike the other categories. And according to the one who says, on the contrary, goring is superior in the sense that one's liability in a case of goring is more apparent, is more obvious, as the objective of the ox's action is to cause damage. Even goring can be derived from the common factor of 2 sources. So the Gemara asks, but if all the categories can be derived from another category and pit, right? As soon as you compare any of these categories with pit, you see what all, and you say, what is the common denominator between pit and any one of the others? Then that common denominator will apply to all of them. That's what the Gemara is now saying. But if all of the categories can be derived from another category and pit, for the purpose of deriving what law did the merciful one write in his Torah, all the primary categories explicitly. If you could have figured out what would happen in the case of fire or, eating, just by knowing pit and goring, let's say, then you could work out all of them. So then why did God actually write out these explicit cases of the fire, of eating, of trampling, of goring, and of pit? Why, if we could have derived all of them just by having had 2 of them, why did God explicitly mention all of them in the Torah? And the Gemara answers, it is in order to derive their unique laws, right? Once these things have happened, there's different outcomes, right? The way that we're going to pay damages is a little bit different. It is in order to derive their unique laws that apply exclusively to each category, that each category is mentioned in the Torah explicitly. And the Gemara elaborates, goring is written explicitly in order to distinguish between the laws of damages caused by the innocuous ox and the habitual gorer. Eating and trampling are written explicitly in the Torah in order to exempt from liability those whose animals perform the actions in these categories in a public domain. If your ox eats something that's just lying around in the public domain or walks over something that's in the public domain, unless like you were somehow negligent to lead him to something, the person who just left it lying around where it could be trampled or where it could be eaten assumes part of the liability, and enough so that eating and trampling do not lead to damages if they happen in the public domain. It only has damages if your ox eats produce or it tramples stuff in a private domain, obviously not yours. Your ox went into your neighbor's property and caused that damage. Pit is written explicitly in the Torah in order to exempt one from liability for damage to vessels caused when they fall into a pit. And the Gemara adds, and according to the opinion of Rabbi Yehuda, who deems one liable even for damage to vessels caused when they fall into a pit, pit was written in order to exempt one from liability for the death of a person who was killed by falling into a pit. Rabbi Yehuda concedes that the owner of the pit is exempt because the person who ultimately fell into the pit was capable of avoiding it. That's not to say that you're not going to have damage that you owe, and maybe even, wrongful death. You might owe damages for wrongful death, but you're not liable for murder because you left a pit in the public domain. Now, man, if Bava means man, this is written explicitly in the Torah in order to render him liable for the 4 additional types of indemnity, right? When a person damages another person directly with his own hand or something that he throws or propels, so then in addition to the physical damage, you have the pain, humiliation, medical, and loss of livelihood. Fire is written explicitly in the Torah in order to exempt one from liability for damage caused to a concealed object. For example, if a person was hidden by grain that was consumed by fire. And the Gemara asks, and according to Rabbi Yehuda, who deems one liable even for damage done to a concealed object that was damaged by fire, to add what law then? Does the Torah mention the category of fire explicitly? And now we're on page 6a. And the Gemara answers, it serves to add cases where the fire scorched another person's plowed field, and also cases in which it singed his stones. Even though the damaged object remains intact and is not consumed by the fire, one is still liable to pay for the damage caused, right? That's particular to the category of fire, and we're not going to find that same exact law in any of the other categories of damages. Now we skip a few paragraphs. So what is different about pit that defines it as a unique category? It is that its initial formation, i.e. the digging of the pit, is done in a manner that can result in damage. And it is your property, and it is your responsibility for its safeguarding to prevent it from causing damage to others. It's incumbent on you to do that. So with regard to these items that he had placed on the roof, also, in other words, if you have your stone, your load, or your knife that's on a roof, and then a wind comes and blows it off the roof, so two things could happen then. One is while it's falling to the ground, it hits somebody and injures them, and that's going to be likened to fire. Or it could just hit the ground and come to rest on the ground, and then somebody could stumble over it or hurt themselves, and then it's going to be likened to pit. So with regard to these items that the man had placed on the roof, also their initial formation, meaning when the obstacle reached the public domain, when it became a hazard, because it fell off your roof, well, this is done in a manner that can result in damage. And they are your property, and it was your responsibility for their safeguarding to make sure they don't hurt anybody, right? You should have secured those items on the roof so that the wind couldn't blow them off. So perforce, there is no need for the common denominator in the Mishna to teach the case where the objects fell from the roof, came to rest in the public domain, and were declared ownerless. That case is included in the primary category of pit that is explicitly mentioned in the Mishnah. So rather, perhaps the common denominator serves to teach the law that one is liable even in a case where one did not declare these items ownerless. It's not like, oh, they're not mine, not my problem. Even if they say, no, yeah, those are mine. The Gemara asks, according to Shmuel, who says, we learned that one is liable to pay for damage caused by all obstacles that one places in the public domain, whether or not he declares them ownerless. I'm not saying he denies that they were his. A person could just say, well, I left them in the public domain because they're no longer mine. I declare them ownerless. I abandon them. They're not my responsibility anymore. Hey, tough. If you created a hazard in the public domain, it doesn't matter that you don't expect to recover those items. You created the hazard. And of course, you're going to be liable for that. But we might need an additional provision to establish that liability. Now, the Gemara asks, according to Shmuel, who says, we learned that one is liable to pay for damage caused by all obstacles that one places in the public domain, whether or not he declares them ownerless. And where do we learn that? From the laws with regard to the pit, right? This is a subcategory of pit. You dig a hole in the public domain, people are harmed by it, is the same as, or a subcategory of that is if you leave objects that could cause harm to others lying in the public domain. And we know that from the law of the pit. So why do we need these extra categories? And the Gemara answers, actually, the Mishnah teaches one's liability in a case where one declared the objects ownerless. And even if he declared them ownerless, these objects are not. And even if he declared them ownerless, these objects are not similar to the primary category of pit. Oh, but they're just lying there, causing harm. Just like when I dug a pit in the public domain and I left it there and it was sitting there not moving and it caused harm. What's different? What is notable about the primary category of pit? It is notable in that there is no other force involved with it in causing damage. Will you say the same with regard to these cases where there is another force involved with it in causing the damage, i.e., the wind that propelled these objects off the roof to come to rest on the ground? So we're not just talking about a case where you went outside and left your hazardous materials on the street saying no longer mine, but rather where you didn't intend to do that, it was on your roof, the wind blew it off, it went out there, and now you're like, yeah, well, I don't want it back. You know? You don't get to skate because of that. But does it come under the category of pit, or are we going to say actually it's more related to fire? So the Gemara suggests if one attempts to challenge the derivation from pit in this manner, it is possible to respond. The law of the primary category of fire will prove that this factor, that there is another force involved with the object and causing the damage, is not a reason to exempt one from paying restitution for the damage, as although there is another force involved in the spreading of a fire, one is liable for the damage the fire causes. So the law with regard to these objects can be derived from that of fire. So the Gemara questions the derivation from fire, but what is notable about fire? It is notable that in its typical manner, fire is notable in that its typical manner is to proceed from one place to another and cause damage. Will you say the same with regard to these objects that were propelled by the wind into the public domain, but once they landed there, it is not their typical manner to proceed and move around and cause damage? So accordingly, how can one learn the law in this case from that of fire? Right? They didn't contemplate that what the thing that fell off your roof might be like some AI robot that could go nuts and cause a zombie apocalypse, right? It doesn't have a living spirit, but it certainly is mobile. Presumably that would be like a case of fire. But these non-mobile objects that, aren't robots or whatever, that fall off your roof and cause harm just by lying there, maybe those, are they more like fire or are they more like pit? Wind was, played a part in bringing them out to the public domain, but after that, they don't keep moving. So, the Gemara suggests, if one attempts to challenge the derivation from fire in this manner, it is possible to respond. The law of the primary category of pit will prove that the lack of this characteristic of a typical manner being to proceed and cause damage is not a reason to exempt the owner of the objects from paying restitution for the damage. That's the nature of a pit. You dug it, it's dangerous, it's in the public domain, and it's not moving. So the Gemara notes, and as pit and fire each prove that the defining characteristic of the other is not decisive in establishing liability or exemption, so the derivation has reverted to its starting point, and liability in these cases is derived from the common denominator of pit and fire. And this is the law added by the common denominator stated in the Mishna. So Rava said, the stating of the common denominator in the Mishna serves to add the law that one is liable in a case of pit where an object is rolled by the feet of a person or the hooves of an animal. This is a case where one placed an obstacle in a public domain, and the obstacle caused no damage where it was placed, but subsequently was kicked by passersby to a different location where it caused damage. Right? It's pretty interesting, right? A ball fell off your roof. Okay, so the ball fell off the roof, and then it was lying like right next to the sidewalk, not doing anybody any harm. But a little kid came by, saw the ball, kicked it. The ball went out into the street. A car freaked out, caused an accident, right? So there was definitely this independent factor that became involved in the chain of events. How do we assess liability? The Gemara asks, what are the circumstances in which one is liable for damage in that case? If it is a case where one declared the objects ownerless, both according to Rav and according to Shmuel, then this is the subcategory of pit. Therefore, one could claim what is different about pit, that it is defined as a unique category. It is that its initial formation, i.e. the digging of the pit, is done in a manner that can result in damage, and responsibility for its safeguarding to prevent it from causing damage to others is incumbent upon you, the owner. With regard to these objects, too, their initial formation, i.e. when the obstacle reaches the public domain, is done in a manner that can result in damage, and responsibility for their safeguarding to prevent them from causing damage is incumbent upon you, the owner. Perforce, there is no need for the Mishna to state their common denominator to teach the law in the case where the objects came to rest and are declared ownerless. That case is included in the primary category of pit that is explicitly mentioned in our Mishnah. So rather, perhaps the common denominator serves to teach the law that one is liable even in a case where one did not declare the objects ownerless. And the Gemara asks, according to Shmuel, who says, we learn that one is liable for damage caused by all obstacles that one places in a public domain. Whether or not he declares them ownerless, doesn't matter. You put it in the public domain, it caused damage. What difference does it make to the public, especially the victim who was injured by it, whether you deemed it ownerless or not? From the laws regard, and Shmuel derives that from the laws with regard to one's pit. And this is a subcategory of the law of the pit. So what law does the common denominator in the Mishnah teach? And the Gemara answers, actually the Mishnah teaches one's liability in a case where one declared the objects ownerless, and even if you declare them ownerless, those objects are not similar to the primary category of pit. How's this? What is notable about the primary category of pit? It is notable in that one's actions, the digging of the pit, cause the damage. Will you say the same with regard to these cases where one's actions do not cause damage? Rather, it is the feet of the passersby that cause the damage. That kid who came along and kicked your ball that fell off your roof and went out in the street and caused an accident. That's what caused the accident, right? Not you when you put a ball on your roof. So the Gemara suggests, if one attempts to challenge the derivation from pit in this manner, it is possible to respond like this. The law of the primary category of ox will prove that this fact, that one's actions do not cause the damage, is not a reason to exempt one from paying restitution for damage, as although the owner of the ox didn't do anything to cause the ox to go and gore someone, right? I mean, he failed to restrain the ox properly, perhaps, but he didn't, initiate the action. Whereas the one who dug the pit, there just wouldn't have been a pit if he had not dug it. So the fact that the final action was not caused by the owner doesn't exempt the owner from damage in the case of the ox. Likewise, the guy who put the ball on his roof, why should it matter? It was his ball. It fell off the roof. Okay, then a kid came along and kicked it, but he should have secured the ball on the roof. And the Gemara notes, and as pit and ox each proves that the defining characteristic of the other is not decisive in establishing one's liability or exemption, so our derivation has reverted to its starting point, which is that the defining characteristic of this primary category of ox is not similar to the defining characteristic of that category of pit, and liability in these cases is derived from the common denominator of pit and ox. So while we can say that they have a lot of things in common, it's not uniformly systematized, and that explains why the Torah listed all these cases explicitly and why they each teach something unique. Even though they have a lot of things in common, we really couldn't have derived all the other cases from any two. Rav Ada bar Ahava said the stating of the common denominator in the Mishnah serves to add the law that one is liable to pay damages. In this case, that is taught in a baraisa. Okay, let's see how does this baraisa change everything. With regard to all those people who engage in activities that the sages are permitted. That the sages stated are permitted, right? People who do stuff that the sages deemed permitted, okay? i.e., those who open their gutters and drain the sewage from their houses into the public domain. Gross, but, in ancient cities, that's how they handled it. They didn't have underground sewage systems, in most cities. Maybe the Romans did in a few places, but that was really rare. Basically, any city you went to in the ancient world, and I'm sure Bill is already typing, the modern nose would cringe, right? Walking down the street of most ancient cities, where, actual residential districts. Right? So the sages said it was permitted. Those who open their gutters and drain their sewage from their houses into the public domain, and those who flush out the water from their caves where foul-smelling water was stored, and they do this into the public domain during the summer. No, they do not have permission to do that in the summer. while during the rainy season, they have permission. Now, you see, the system works. In the rainy season, okay, you can dump your sewage in the street because the rain is going to wash the sewage away. In the dry season, no, you're going to make a cesspool out of the whole city. Take the walk out to the edge of the city if necessary. So, although all these people perform their actions with permission, if they cause damage, they are liable, right? So even in the rainy season when it's permitted to dump your sewage in the street, if it ends up that your sewage actually causes damage, you gotta pay, right? Yes, it was generally permitted, but the way that you did it and the place that you did it and the situation that you did it and the amount of sewage that you ejected caused harm. So guess what? You're liable. So the Gemara asks, what are the circumstances in which one is liable for damage caused by the sewage? If the sewage causes damage as it is moving, after he poured it into the public domain, it is damage caused by his own direct action, and it is no different from any other damage caused by a person. According to Rav, this is Maveh. According to Shmuel, it appears in the next Mishnah, and it is not derived from the common denominator mentioned in our Mishnah. So rather, it is in a case where the damage was caused after the sewage came to rest on the floor. For example, a passerby slipped on it. So the Gemara asks, what are the circumstances? If it is a case where one declared the sewage ownerless, presumably anyone who dumps their sewage in the street does not intend to recover it, the Gemara asks, what are the circumstances? If it is a case where one declared the sewage ownerless, both according to Rav and according to Shmuel, this is the subcategory of pit. You created a stationary hazard in the public domain. You're liable like you'd be liable in the case of a pit. What is different about pit that it is defined as a unique category? It is that its initial formation, i.e. the digging of the pit, is done in a manner that can result in damage. And it is your property, and it is your responsibility to safeguard it from coming to damage others. So with regard to this sewage, also the initial formation, i.e. placing it in the public domain, this is done in a manner that can result in damage. It is your property, and the responsibility for safeguarding it from damaging others is incumbent on you. So rather, perhaps the common denominator serves to teach the law that one is liable, even in a case where he did not declare the sewage ownerless. And the Gemara asks, so he didn't declare the sewage ownerless, he was just storing it outside until he would later come and collect it and maybe make manure and fertilizer out of it. Well, if that's the case, all the more so you're going to be liable. Why would that be different from the pit law, which we're saying that applies to the ownerless sewage? Let's see. Where he did not declare it ownerless. So the Gemara asks, according to Shmuel, who says, we learn that one is liable for damage caused by all obstacles that one places in a public domain, whether or not he declares them ownerless, from the laws with regard to one's pit. And this is a subcategory of pit. So the question remains, what law does the common denominator in the Mishnah teach? So the Gemara answers, actually, the Mishnah teaches one's liability in a case where he declared the sewage ownerless. And even if he declared it ownerless, it is not similar to the primary category of pit. What is notable about the primary category of pit? It is notable in that the pit was dug in the public domain without permission. Will you say the same with regard to these cases where the sewage was channeled into the public domain during the rainy season with permission? It was legal to do so. Well, but was it with the permission of the one who was injured? It was a permission that, okay, generally people are allowed to do this, but that doesn't mean that if you did it in such a way that it caused harm, that you're going to be innocent of liability. You're not. The Gemara suggests, now we're on 6b, the primary category of ox will prove that this fact, that the ox, i.e. the cause of the damage, entered the public domain with permission, it is not, and the fact that it entered with the category of ox will prove that even though it entered the public domain with permission, this is not a reason to exempt its owner from payment, as that is the nature of the primary category of ox. He's allowed to be in the public domain, but he went and gored someone else. If he ate or trampled, that's not liability in the public domain, but if he gored, it is. The Gemara questions the derivation from ox. Well, wait a minute. What is notable about ox? It is notable that it is the typical manner of the animals in these categories to proceed from one place to another and cause damage. By contrast, in the case of the sewage, It is not its typical manner to proceed and cause damage. Accordingly, how can one learn the law in this case from the primary category of ox? And the Gemara suggests, well, if one attempts to challenge the derivation from ox in this manner, then one could respond, the law of the primary category of pit will prove that the lack of this characteristic of the typical manner being to proceed and cause damage is not a reason to exempt one from paying restitution for the damage, as that is the nature of a pit. And one is liable for damage caused by this pit. And the Gemara notes, and as pit and ox each prove that the defining characteristic of the other is not decisive in establishing liability or exemption, our derivation has reverted to its starting point. Now I'm skipping a few paragraphs because the logic sort of proceeds in the same manner. And now I am just further down, maybe halfway down, 6b. The Mishnah states, and when, a second here. Okay. I'm not that far away from questions. Maybe 10 minutes, maybe less. Okay. So the Mishnah states, and when a component of any of these categories causes damage, the owner or generator of the component that caused damage is obligated, chav, to pay restitution with best quality land. So the Gemara asks, why does the Tana of the Mishnah use the unusual expression, the one liable for the damage is chav to pay? Chav, right, to be chav, in other words, is liable, is chav to pay, is not the way you would normally say it. You normally say to be chayav, to be obligated. Right, so the one liable for the damage is chav to pay. Why does he use this expression? He should have used the more standard expression for liability. The one liable for the damage is chayav to pay. So the Gemara explains, Rav Yehuda said that Rav said this Tana is a Jerusalemite who teaches using a light and concise formulation, as chav is more concise than chayav. Now the Mishnah continues, the owner or generator of the component that caused damage is obligated to pay restitution for damage with best quality land. The one liable for the damage is indebted to pay payments of restitution for damage with his superior quality land. The sages taught in a Baraisa, the Torah states, with regard to paying damages, of the best of his field and of the best of his vineyard he shall pay. Exodus 22:4. You see, it's an explicit Torah commandment. The sages didn't make up that you need to pay out of your best quality land. God said that. So what is the meaning of his field and his vineyard? It refers to that property of the injured party. It refers to that property of the injured party. The one liable for the damage pays from land of a quality that is commensurate to the best quality field of the injured party. Oh, interesting. You're saying that if he has his property and his property is kind of crummy, so that his best property is equivalent to my medium quality, because I have superior quality way better than his best. So if I now damage him and I have to pay him and I have to liquidate some of my land, can I take from my medium quality property, because that's equivalent to the superior quality property of the one I injured? Is that what we're saying? Yes, that, what I just described, is the statement of Rabbi Yishmael. Rabbi Akiva says that the verse comes only to allow injured parties to collect compensation from superior quality land. In other words, the one I injured, he has high, medium, and low quality land, and his best is only equivalent to my medium or even my lowest quality. But if I injured him and I have to liquidate some of my property, no, according to Rabbi Akiva, I have to liquidate my superior quality land, even though it is much better than anything he has. And it makes sense, because the whole idea is I have to make him whole. My best quality land is the one that's going to be easiest to dispose of and turn into money so that I can pay my obligation to him. That's a logical derivation. We're not sure exactly why God said so, but that's one guess. Right? Maimonides says, Rambam says, we can't know the reason for many or most of God's laws, but we are obligated to try and figure them out. Not everyone agrees with Rambam on that point, but it's worth noting. Now the Gemara asks, and according to the opinion of Rabbi Yishmael, right, that I only have to liquidate from my property something equal to his best, the one I injured. And according to Rabbi Yishmael, if one's animal ate from a rich garden bed, it is understandable that he must pay the injured party the value of a rich garden bed. But if the animal ate from a poor garden bed, is it reasonable that he pays the value of a rich garden bed? Well, this is the straightforward meaning of Rabbi Yishmael's statement. It is untenable, as he would be paying more than the value of the damage he caused. So Rav Idi bar Avin said, with what are we dealing here? We're dealing with a case where the animal that caused the damage ate from one garden bed among other garden beds, and we do not know whether it ate from a poor one or it ate from a rich one. In such a case, the law is that the animal's owner pays the injured party the value of a rich one. Rava raised a question and said, and if we would know that the animal ate from a poor garden bed, its owner would have to pay only the value of a poor garden bed. Now that we do not know whether it ate from a poor garden bed or if it ate from a rich garden bed, is it reasonable that he should have to pay the value of a rich garden bed? There is a general principle governing monetary disputes that the burden of proof falls on the claimant. The one trying to receive damages has the burden of proof to establish that the defendant actually is liable and is obligated to pay those damages, right? The one seeking the money has the burden of proof. Therefore, so long as the injured party cannot prove that the animal ate from the rich garden bed, he should not be entitled to collect the value of such a garden bed. So rather, Rav Acha bar Yaakov said, with what are we dealing here? We are dealing with a case where, after appraising the damage, the court comes to collect from the one liable for the damage, but he does not have money available to pay for the damage. And in that situation, the Tanaim, the rabbis of the Mishnah, disagree in a case where the superior quality land, i.e. the best land of the injured party, is equal in quality to the inferior quality of the one liable to pay the damage. And the one liable for the damage also has land of superior quality. That's what we're saying, right? What does he have to liquidate in order to pay his obligation? From his lower quality land, which is equal to the high quality land of the injured party, or from his own best quality land, which is much better than the best quality land in the possession of the injured party. Now, obviously, he's only going to have to make whole the damage that he actually caused, right? So he's only going to have to liquidate as much property as necessary to pay his debt. Nevertheless, from which part of his property does he have to liquidate according to Torah law? And the Tanaim disagree with regard to this. Rabbi Yishmael holds we appraise the value of the land of the injured party, and therefore the one liable for the damage can pay with his own inferior quality fields, since they are equal in quality to the best fields owned by the injured party. And Rabbi Akiva holds we appraise the value of the land of the one liable for the damage and have him pay with his fields that are his best quality. So the Gemara explains, what is the reason for Rabbi Yishmael's opinion? The word field is stated below toward the end of the verse, of the best of his field and of the best of his vineyard shall he pay. And the word field is also stated above at the beginning of the same verse. If a man causes a field or a vineyard to be eaten, and he sends forth his animal and it consumed in the field of another, so just as the field which is stated above belongs to the injured party, so too the field stated below belongs to the injured party. We assess according to the field of the injured party. So then why would Rabbi Akiva say that we have to liquidate the owner, the damager's best property in order to pay his debt, even though his animal might have injured much lower quality land in the possession of the injured party? Well, Rabbi Akiva holds when the verse says of the best of his field and the best of his vineyard he shall pay, it means from the best of the one who is paying, right? What we're arguing about is the word his, right? Of the best of his field he shall pay. His, who? The damaged party or the damager? And Rabbi Yishmael says when we're talking about measurement of what field we have to liquidate to pay, the one who is injured. And Rabbi Akiva says his field means the guy who owns a field that has to sell it in order to pay what he owes the guy that he injured. And then how would Rabbi Yishmael answer Rabbi Akiva? The verbal analogy between the two instances of the word field is effective, and the straightforward meaning of the verse itself is effective. The verbal analogy is effective, as I stated, Rabbi Yishmael's opinion. It serves to teach that when it says he pays from the best of his field, it means the land equal in quality to the best field owned by the injured party. And the straightforward meaning of the verse itself is effective. That supports Rabbi Akiva's position. It says, of the best of his field, he shall pay. Right? The best of the damager. Very close to done. Any questions or comments? Get them in. So in this case, the law is that one is liable, that the one liable for the damage pays the injured party from his own best land. So we follow Rabbi Akiva, and this is as the one liable, and why? This is as the one liable for the damage is legally unable to say to him, well, you should come and collect money from my inferior quality land. He cannot say this because the standard for classifying land as being superior quality is set according to the injured party's superior quality land, and the inferior quality land, or the one liable for the damage, is of a lower quality than that. So rather, the injured party collects his damages from the best quality land of the one liable for the damage. I think that I think that really the best reason that we follow Rabbi Akiva in this, first of all, it's Rabbi Akiva, but also because it's a straightforward meaning. I mean, the Peshat, like the simple surface meaning, is so clear that for me, that's the best argument for why and also it produces speedy justice, right? It's going to be easier to liquidate the damager's best quality land, however much we need to, in order to create, the bag of money that he's going to be transfer to the injured party in order to make him whole. Okay. Right. So a couple of questions. Joseph, are there special laws concerning animals that fall into a pit? Are there special laws concerning animals that fall into a pit? Yes, and we're going to cover them. Sharon, if you have items on your roof and you do not have a parapet as you should have, that might have prevented things from falling off, does that change your culpability? What a wonderful question, right? So Sharon is saying that not only do we have a general responsibility to secure items on our roof from falling off and coming to damage people as they fall or once they're lying in the public domain, but the Torah says that you have to have a parapet on your roof to protect people from falling off your roof. And if you had that parapet, maybe this wouldn't have happened. So the thing is, not having a parapet and then somebody falls off your roof seems to me like then you might be liable, for a type of negligent murder. Second, if you don't have a parapet, whether somebody gets hurt or not, that's a transgression, right? I guess it's in other words, it's a lack of doing a positive mitzvah that can be rectified by doing the mitzvah, right? It's a positive mitzvah to put a parapet on the roof. But I also would say, right, as a recovering attorney, that would be further evidence of negligence, right? In just establishing the first case that you should have secured it. Look how negligent this person is. Not only did he not tie down the stuff, he doesn't even have a parapet on his roof like all, Torah Jews do and should. But I'm not sure if it's dispositive. If the kid kicked, is the unattended child considered in the category of ox? Interesting, right? So now, right, like, how lawyers do, sue everybody, right? So if that ball that caused the accident, right, fell off someone's roof, okay, so one idea is we're going to sue the owner of the house that had the ball on the roof that was unsecured, that came down to the public domain, that ended up being kicked by the kid. Could we also sue the parent of the kid who had an unattended kid, running around, and maybe is that an innocuous ox? Or actually maybe that's like a habitual gorer, or in this case, the forewarned ox, right? Because the parent has to know that an unattended child can cause damage in a public domain. For sure, a child can cause damage in a public domain. That's a great question. So maybe they would have a viable cause of action against both parties for different theories, right? The ball off the roof is like a pit or perhaps fire, and the child maybe is like an innocuous ox, or maybe like a forewarned ox, slash habitual gorer. Great. Bill, you were correct. I was writing as you spoke. It was not rare in Roman cities. Pretty much every city that the Romans built from the ground up had them, but here's the trick. Ancient sewers weren't for what we today would call sewage. They were for controlling rainwater runoff and preventing flooding. Practically, that meant sewage did end up there, but that's not what they were built for. And yes, ancient cities were often quite pungent with sewage, smoke, animal smells. Give thanks for modern sanitation. That's all I can say. Very good. Nina's reminding me that we have to attend an event tomorrow night for the Jewish Journal of LA. We edit the table for 5. I believe, right? Last I heard, it's confirmed, have a big article coming out in the Jewish Journal this coming week. But there's an event for the Jewish Journal tomorrow evening. I don't want to cancel class because we're behind. So let's do class tomorrow 1 hour early at 5 p.m. 5 p.m. class tomorrow, 5 p.m. Pacific, just 1 hour earlier than normal will be the time tomorrow. Look forward.